And we are live. So good morning and good afternoon to everybody on the panel and around the world. Really a warm welcome to you all today from the University of Aberdeen Centre for Energy Transition and the Aberdeen University Centre for Energy Law for this fantastic book launch that we have today on National Climate Change Acts, the emergence, form and nature of national framework climate legislation, a hugely significant and important issue for advancing climate change action around the world. And we've got a fantastic panel of thinkers, legal scholars and policy experts around this topic. So it's my pleasure to introduce them all today. First, I'll introduce Dr. Thomas Musner, who is a co-director of the Aberdeen University Centre for Energy Law. And Thomas, please if you step up and introduce yourself and the book and the welcome note. So welcome everybody and enjoy this fantastic event. We look forward to some great questions and conversation afterward. Over to you, Thomas.
Thank you very much, Tavis, and welcome to all. Very nice to be here with you today. I'm Thomas Musner, the co-director of the Aberdeen University Centre for Energy Law at the University of Aberdeen. And I'll just begin, as Tavis indicated, with a welcome note from Lord Karnwith. Lord Karnwith provided the foreword to the book that we're launching today, and he was a very eminent Supreme Court judge who just stepped down from the bench relatively recently. He sends apologies for not being able to be with us in person online, but we have this very kindly sent welcome note, so I'll just read that now. I'm very sorry not to be able to participate directly in the launch event for this important new work. The timing is particularly appropriate in the run-up to COP26 conference in Glasgow later this year. As I said in my introduction, so the foreword to the book itself, it is time for us all as members of the legal community, whether as judges, as practitioners or academics, to be thinking what we can do to assist the development and improvement of effective laws and legal institutions here and elsewhere to meet the challenge of climate change, and how we can feed that thinking into the COP26 process. Effective legislation at national level is ultimately the only way in which the commitments under the Paris Agreement can be given real substance. The present work makes a major contribution to that process by offering expert comparative study of the strengths and weaknesses of the different systems around the world. It deserves every success. Robert Karnwith, June 2021, and he wishes us all the best of luck and warm regards for the launch itself. So there's a book called The Namesake by Lahirian author I was reading recently, and in that novel the author points out that one of the great things about books is that they let you travel without moving your feet, which I think is a nice sentiment. And perhaps one of the great things about book launches in this context is we can travel without moving our feet. Due to circumstances, we're launching this book remotely online, but it's still nice to be able to travel together for this event, as it were. It's a shame we couldn't be together. We had initially intended to launch things at COP last year, which was delayed, of course, due to COVID, but it's lovely that we can come together to celebrate this launch remotely today. I'd like to stick on that brief theme of celebration, which is what this is today, in no small part, and in doing that, I think it's suitable to come to some acknowledgements in relation to the book. Now, of course, I gratefully acknowledge the support and involvement of Tavis Potts, who's spoken, the director of the CET here at the University of Aberdeen, and his technical team, who've been wonderful, and other colleagues who've been involved in helping facilitate the event. Also, thanks to the Aberdeen University Centre for Energy Law here at the university. But in terms of the book itself, I think it's nice to acknowledge some people that have been very important in its process. Firstly, Professor Volker Robson, who's a very distinguished German energy lawyer. And when the book really initially got off the ground as an idea that was planted as a seed, Prof. Robson and I happened to work in offices next door to one another. Prof. Robson was involved in quite an exciting book series that was coming out. I'd been sitting in my corner of the universe next door cogitating on some kind of technical problems around climate change acts. And I went next door and I said, about that book series, I think I might have something here. And Volker is a very busy guy. Rather than shooing me out the door, kindly said, sit down, let's hear it. We had a chat, and that was the seed being planted for the book that we've communally put together with friends and colleagues on the panel. And Volker was very supportive throughout that process. Then with the book, after conversation, you have all sorts of other things, book proposals, engaging with publishers, and so on. The idea was very well received by Hart, who published the book. And again, in addition then to acknowledging Volker's kind contribution, Roberta Bassi at Hart should be acknowledged in particular, I think, very supportive of the project and helped steer through the process, and very delightful person who understood the ideas behind the book as well and championed them as a part of the process. Anna Marie McAlinden, who's a partner at Mills Selig Solicitors, and then Professor Gavin MacLeod-Little, now Professor Emeritus Gavin MacLeod-Little of the University of Stirling, both played a very important hand in peer reviewing chapters behind the scenes, including my work, gave me very rigorous review. I'm contributing editor to the book and includes writing of my own. They were wonderful sort of colleagues in terms of providing that background support in particular. And of course, Lord Karnwith, who kindly sent those delightful sentiments and provided the foreword to the book. And it's probably fair to say, I think Lord Karnwith is probably really the only preeminent environmental lawyer, in a sense, who's arrived at the Supreme Court bench. In a sense, he's probably, we could maybe debate the point, but he's made particularly important contributions to planning law and environmental law, and he also gives a very important personal contribution to environmental issues and matters. And since he stepped down from the Supreme Court bench, he's still very heavily involved in trying to galvanise useful legal thinking, progressive legal action in the area of climate change and so forth. So it's a particular pleasure to have had his support and involvement with the text. I'll come on briefly to the substance of the book and shortly hand back to Tavis. Now, the book's titled National Climate Change Acts, the Emergence, Form and Nature of National Framework Climate Legislation. As we know, I'm the contributing editor. We've got friends and colleagues here who are going to talk about their contribution. Let me just briefly define what we're talking about. I'll define Climate Change Act from the book. The definition we use is reduced to its minimum logical foundations, a broad national legislative framework that has been set in place by a state legislature as an act of parliament or equivalent for the purposes of redressing specific problems posed by climate change in an overarching or otherwise broadly strategic manner within that particular country, or for shorthand, something we might describe as national framework climate legislation, which is in the title, of course, itself. Very briefly, these sorts of acts really emerged in 2008 in the UK with the Climate Change Act 2008, and then they start to slowly proliferate around the world, and that process is going on now. They engage with a very key issue, one of the great problems of our times, an existentialist problem, climate change. That will need no introduction as a problem, but we're kind of sitting on a cutting edge of law here. These frameworks, they're birthed into the world, if you will, in 2008 in the UK. They begin to proliferate, they begin to adapt, evolve, and what we were trying to do in this book, reduced to its essentials. As a team, I see it as a team effort because the book sort of speaks in concert and is coherent rather than just random isolated chapters. It's very sort of coherent work. We're collectively really trying to get to grips with these new emergent frameworks, trying to interpret them, trying to understand them, and really provide the first comprehensive book length effort that constructs a deep dive research statement on that particular form of law. That's fundamentally what we're endeavouring to do and do in the book, and so that can be better understood. And when you get to the latter portions of the book, it's particularly, I think, exciting because based on all the great work by Asa and Richard and other people here, and some others who couldn't be here today, we're able to knit together those chapters and draw some fundamental lessons that apply to climate change acts in a general sense for the first time, and we can sketch out components that appear to be elements that would be usefully included in an optimized national framework climate change act. So all of that's quite important. That means if policymakers, legislators are working on these types of acts, this book will be a very useful resource, and it has had some quite impactful traction. It's been part of the conversation in Ireland where amendments to its Climate Change Act, which Andrew treats so well in the book, are going through at the present time. It's directly informed developments in the Northern Irish Climate Change Bill, which is in the devolved Parliament in Northern Ireland, brought forward by Claire Bailey, and also the intellectual contribution, the contribution to understanding, I think is a important one. I'll turn over to Tavis in a moment, but I'll just also stress that this, as I use the term first comprehensive research statement in book form advisedly, it's a beginning, not an end. So it's a first, it's a start, not a conclusion. These acts are emerging, they're developing, they're proliferating. It's a very exciting area of law. It's a very important area of law. And this book perhaps could be read usefully in a continuum with some other texts. I mean, Elena is going to speak to us. She's a very good book called Trends in Climate Legislation, which helped inform our thinking. Grantham have produced a subsequent report since we've done this in Climate Change Acts, Ecologic. The conversation goes on. So an exciting thing I think about the book as well as you read it is to try and remember and recognise this is part of an ongoing conversation, very important conversation, as we try to understand the contribution that law is making, could make, should make in this key area. And the sands continually shift, so there's always more work to do. So I'll end there. Thanks for listening. I'll turn back to Tavis, who I think will, in due course, invite friends and colleagues who contributed to the book to speak. Thank you.
Thanks a lot, Thomas. That's a fantastic introduction to this really, really interesting and important book. And I'm very interested in this topic. I can't wait to read it. I think it's going to be a really important scholarly contribution to the field, but also a really important contribution to the practice and the application of law and the development of policy of implementing climate change commitments and the ambition and commitments of states to doing this, of reduction of greenhouse gas emissions to meet our global Paris targets. So without further ado, it's my pleasure to introduce a fantastic lineup of speakers today from all around the world to give us their insights into climate change legislation in the national context. So it's my pleasure to introduce Professor Richard Macquarie. Richard is a barrister and a member of Brick Court Chambers, London, and in 2000 he was awarded a CBE for services to the environment and law, and in March 2008 he was made Honorary Queen's Counsel. In 2010 he was elected a Bencher of Gray's Inn, and Professor Macquarie joined the faculty of University College London in 1999. He'd previously been teaching in Imperial College and was the director of the Environmental Change Institute, which I know very well, at Oxford University. Richard was also a member of the Royal Commission on Environmental Pollution, a fantastic achievement and one that we know very well in the environmental science field as well. Between 1992 and 2003, and was a board member of the Environment Agency in England and Wales between 1999 and 2004. He's the founding editor-in-chief of the Journal of Environmental Law and is currently the legal correspondent to the ENDS report. So Richard, that's a stellar list of achievements there and fascinating things that span law and environmental science. So over to you, the floor is yours.
And just to check, you can hear me? Yes. Good. Okay.
Loud and clear.
Well, thank you very much. Well, my first serious involvement in UK climate change law and policy was 21 years ago, when I was a member of the Royal Commission on Environmental Pollution, which you mentioned, and its 2000 report on energy and climate, changing climate. Now, we early on in that study decided that the best way was to look forward and ask, where do we need to be as a country on climate change by 2050? Now, that was a date we chose as being reasonably long term, but not totally out of current horizon thinking. Indeed, there were decisions then being taken on, say, the energy efficiency of housing, which would impact within that time frame and beyond. And I think what struck us then was how little detailed thinking there was in government on longer term energy scenarios. On climate change, the whole preoccupation then was with meeting the Kyoto targets to be met between 2008 and 2010, but really nothing long term. And ironically, perhaps the only organisation at that time that seemed to be seriously engaged in longer term energy thinking was Shell. Now, we recommended that the government commit itself to a greenhouse reduction target of 60% by 2050, which that seemed right at the time in the light of the then scientific thinking. And on the day that the report was published, the British Prime Minister, Tony Blair, endorsed that recommendation. Now, I don't think he'd read the small print, because the Royal Commission had come up with that figure for the UK, largely based on an acceptance of the contraction and convergence principle for global reduction, a policy which certainly then the government did not support. Anyway, by the time the Climate Change Act was passed in 2008, the science had moved on and the figure was increased to 80%. And as you may well know, that was amended to 100% in June 2019. Now, neither I or the Royal Commission was involved in the details of that legislation. And I have to admit that personally, I've changed my views about that legislation. When I first read the Climate Change Act, much of it seemed rather too vague and aspirational for a rather hard-nosed lawyer. And I did wonder whether this was more of a public relations exercise rather than something that would seriously change thinking. Now, I think I've changed my view since then. I think it's actually a rather clever piece of legislation designed to deal with a new sort of environmental challenge. It's one that combines legal and procedural requirements. It injects relentless political accountability of government to Parliament for its progress, and it provides for independent scientific critique through the establishment of the Climate Change Committee. But at the same time, there is a fair degree of adaptability, allowing the longer term targets, for example, to be tightened up as they have without the need for new primary legislation. And it provides a good deal of policy flexibility to government on how to achieve those goals, but against a framework of legal obligations. And I think in many ways it's remarkable that the Climate Change Act has been supported by all political parties, and it survived a Labour government, a coalition government, and now a Conservative government. So let me end by just making 3 points about the law. The Climate Change Act starts with a very simple statement in section 1, to quote, "It is the duty of the Secretary of State to ensure that the net UK carbon account for the year 2050 is at least 100% lower than the 1990 baseline." Now, as lawyers, we can argue about what that actually means. Is it a legally enforceable duty? But it's very rare, in my experience, for an environmental law to be so upfront and clear as to its basic goal and obligation. And there are no qualifications which are normally beloved, certainly by British draftsmen, such as far as reasonably practicable and so on. And I think it means that it gives that provision a very significant political resonance. I mean, any member of the public, whether they are a lawyer or a non-lawyer, can readily understand and support that provision. And that's not unimportant in this field. Second, the inclusion in the legislation of a long-term target that was then combined with legally binding budgets over every 5 years provides an important ratchet designed to ensure a fairly smooth trajectory towards a long-term goal, and providing at the same time clearer signals for industry and investors. Now, the government's acceptance this year of the 6th budget for 2033 to 37, as recommended by the Climate Change Committee, is a significant step, and the regulation should be approved by Parliament this month. Until now, basically, government has been able to meet the existing targets and budgets without too much disruption. The 6th budget, which commits to a 78% reduction from 1990, will be the really serious policy challenge. And I think it's one that is likely to impact on the general public in a way that perhaps hasn't happened before. But it will be in the law now, and it will be difficult to change. And then finally, we have over the last few years seen an extraordinary growth in climate change litigation in the courts around many countries, and courts in countries such as Ireland, Germany and the Netherlands have provided highly critical judgments of the adequacy of their government policies. Now, we've already seen some litigation in this country. I think, though, that it's unlikely the courts will challenge the overall adequacy of the ambitious goals which are now embodied in the Climate Change Act. We're not going to get that sort of litigation. And I suspect the focus of any litigation, if it comes, will be on the legitimacy of existing and emerging policies to meet those goals. Thank you very much.
Thank you very much, Richard, for that fascinating background and insight into the development of the UK Act and some of the challenges for going forward, both in the policy and the societal elements as well. So many interesting years yet ahead on that front. Now I'll swiftly hand over. It's my pleasure to introduce Dr. Elena Avecinkova. our friends down at the Grantham Research Institute on Climate Change and the Environment, the London School of Economics. Dr. Avecinkova leads the Governance and Legislation Research team at the Institute and focuses on the analysis of the implementation of the Paris Agreement, national climate governance, and climate legislation. She has over 18 years of experience in this area, having previously worked for the global consultancy KPMG, the UN Framework Convention on Climate Change, and a carbon asset manager in First Climate and Environmental Defence Fund. So, Elena, the floor is yours. Thank you very much, and you bring a very experienced background and insight into this debate. The floor is yours.
Thank you so much. It's been a great pleasure to contribute to this volume, and I focused on the case of Mexico, which is quite different from the one Richard just presented in the UK. Mexico is the world's 10th largest greenhouse gas emitter, and it's expected to become the 7th largest world economy by 2050. And the case of Mexico is particularly interesting in terms of legislating on climate change, because for years, talking to parliamentarians, to policy experts, we would cite the UK experience in Climate Change Act, and talking to developing country audience, you would get asked, well, it's very well for the UK to do that, but our circumstances are very different, and why should and how can an emerging economy legislate on climate change? And I think Mexico's example is an excellent one in that sense. So Mexico in 2012 became the first large oil-producing emerging economy to adopt a comprehensive legislation on climate change. And my contribution to the volume focuses on the pathway towards adoption of the law. What were the key factors that led to it, in particular the political leadership that Mexico was taking in the international arena at the time, the personal commitment of President Calderon to the climate change agenda, and also very active engagement of environmental NGOs. So really some key political domestic factors and international factors aligning together. However, the pathway has not been easy. Mexico has faced furious opposition from gas and oil producers domestically, and the negotiation of the law took about 2 years with a lot of legislative initiatives on the way. And unfortunately, while the law has established really key elements of the institutional framework for climate policy in Mexico, some of the targets were weakened in the final process of negotiation. Nevertheless, the 2012 General Law on Climate Change, Ley General de Cambio Climático in Spanish, established the overall direction for climate policy in Mexico, aspirational goals on mitigation, and emission reduction targets for 2020, which are conditional on international support. It has also established key institutional arrangements for coordination of climate policy in the country, for monitoring and evaluation of emissions, and also, most importantly, provided pathway for future increase of ambition in that area. And very specifically, our assessment of the developments in climate policy in Mexico show that General Law on Climate Change has enabled another piece of legislation, which is Energy Transition Law, which has transformed the energy sector and really orientated energy policy towards great attention to renewables, enabled investments in that area. And there are various expert assessments that point out that without the General Law on Climate Change, that law wouldn't have had such success. Second important development was that Mexico has taken a decision in 2018 to amend its climate change law towards great level of ambition, to bring it into consistency with the Paris Agreement. So Mexico was one of the first countries to actually amend the targets in its domestic climate legislation to make them consistent with their international commitments made in the nationally determined contributions to the Paris Agreement. So the chapter also goes in detail through the amendments of the law introduced in 2018, specifically recognition of the overall objective for climate policy to keep global warming below 2 degrees and make the best efforts to stay within 1.5 degrees. more ambitious targets for mitigation overall for the Mexican economy, and also introduction of sectoral objectives for the key sectors. Very important legal innovation, I think, of that amendment is that Mexico was the first country to put a provision that any future amendments to the law should only be in the direction of increased ambition, which is in line with the Paris Agreement, which is very interesting in its own. And finally, the chapter looks at what can we learn from the experience of implementation of the law and what impact has it had both on Mexican climate policy, on the political debate, but also on concrete initiatives on reducing emissions. And what we find that the political significance of the law has been very important in terms of setting up the institutional and governance infrastructure on climate change in Mexico. However, with the recent political changes and the new administration coming in 2018, we see the government actually taking its turn away from the ambitious objectives of climate legislation. So it will be interesting to see going forward to what extent climate law can actually help keep Mexico on track and meeting its climate objectives. Thank you so much.
Thank you very much, Elena, from that message. Is a really interesting case study from Mexico. So we'll swiftly hand over now to Prue Taylor, our good mates down in New Zealand, and I hope everything is well, close to home. And it's a delight to have you here today and joining us quite late in the evening as well. So Prue's received her qualifications from Victoria University, New Zealand, and Tulane University in USA. Prue teaches environmental and planning law at the School of Architecture and Planning and is the Deputy Director of the New Zealand Centre for Environmental Law, an elected member of the IUCN Commission of Environmental Law and its Ethics Specialist Group. Prue, the floor is yours. I'm delighted to have you here and look forward to hearing your case study.
Thanks, Travis, and greetings from the other side of the world. It's really nice to be here, although it's kind of a bit odd being, you know, in a totally different time zone, but actually it kind of beats the jet lag that's usually involved in getting to your side of the world. So I just have for everybody 4 very short points that I hope will entice you to be really interested about the New Zealand legislation. And the 4 points that I've chosen, I think are quite unique about the New Zealand legislation. So the first point is that when I wrote the chapter in the book, I was dealing with draft legislation. I was dealing with the bill. And I was expecting that the legislative process would take quite a long time, as it usually does in New Zealand. However, the legislative process moved very, very quickly. And it only took really a year from beginning to end for the legislation to pass through the House and to be confirmed as an Act of Parliament. But unfortunately, that was a little bit late for the writing process. So the chapter, as I've written it, is based on the bill. The Act, when it was enacted, was very, very, very similar to the bill. But there's an editorial note at the beginning of my chapter that just picks up a couple of the substantive changes that were made during the legislative process. But a key point there is that the New Zealand legislation is very new and it went through the House very quickly. So my second point is a little bit about the genesis of the New Zealand legislation. It is based on the UK legislation. But what's really interesting about the New Zealand legislation is that I think we really have the youth of New Zealand to thank for the fact that we really so quickly picked up the UK model and adapted it for the New Zealand situation. And essentially what happened is youth groups really pressured political parties ahead of the 2017 general elections to put climate change on the political agenda. And at the same time, they said, this is how you do it. Go look at the UK legislation. And the political parties largely picked it up, realizing, though, it was going to be very difficult to do because they required bipartisan agreement to really get that legislation through the House. But we had an election in 2017 and the coalition government put climate change right at the front of their agenda and basically said, yes, we will move with similar legislation as the UK. So the third point relates to this difficulty of getting bipartisan agreement amongst the various political parties in order to get this legislation, not only through the House, but to make it enduring legislation. And the difficulty that political parties really had in New Zealand is due to New Zealand's unique emissions profile. And New Zealand is totally unique in the world in that 48% of our greenhouse gas emissions come from the agricultural sector, of which 35% are from methane, which is an incredibly potent greenhouse gas. Farmers really didn't want and still do not want to deal with reduction of methane emissions. So the difficult task for politicians was to get methane in there, in the legislation, because it's such an important gas, but to get it in a way that political parties and farming interests would agree to. So New Zealand took what's called a split gases approach and put two separate targets into the legislation, one for all greenhouse gases except methane, and that's essentially net zero by 2050. I emphasize the net bit, so net zero by 2050, and the separate target for methane was split into two itself, but essentially the most important one is to reduce methane emissions by between 24 and 47% over 2017 levels by 2050. So that's a kind of a unique element of our legislation, and it'll be interesting to see how that's actually delivered upon. The final point is that many of you may know that the New Zealand government has very important legal and moral obligations to the Indigenous people of this land, of Aotearoa New Zealand, and those legal and moral obligations are contained in the Treaty of Waitangi. And that meant that there are some really interesting specific provisions in the legislation that require the interests, the needs, the culture, the traditional knowledge system of the Indigenous people of New Zealand, the Māori people, to be taken into account in terms of emission reductions and adaptation plans, etc. Also, so there are some very interesting provisions in terms of meeting those obligations that the government has. So just two examples of that. We don't have a climate change committee, we have a climate change commission. The commissioners, their expertise of some of the commissioners must include experience of the Treaty of Waitangi and also a deep knowledge and experience of the Māori culture, the Māori language and Māori custom or tikanga Māori. And another element of the legislation to comply with the treaty are consultation requirements. So there are significant additional consultation requirements in the legislation for our Climate Change Commission and for our Minister. Now, on paper, these look very good, but many of my Māori colleagues are underwhelmed with the way the legislation has dealt with the treaty, for the very simple reason that they treat Māori as mere stakeholders, not as partners, and there is no requirement of co-development of emission reduction plans or national adaptation plans. So that may be an area of tension for New Zealand into the future. So those are my 4 points about New Zealand. I hope you'll find that chapter interesting, and it certainly reflects the unique circumstances of New Zealand. Thank you.
Thanks a lot, Prue. That was absolutely fascinating, and that's some really poignant elements there about how the Treaty of Waitangi interacts with the climate legislation, and you're talking about issues around cultural inclusion and climate justice and social justice as very much a part of the process of legal development as well, which is really interesting. Thank you very much. Now over to Andrew Jackson now to talk about Ireland's Climate Change Act. And Dr. Jackson is Assistant Professor in Environmental Law at the University College Dublin. He's previously worked for the firm Slaughter and May and for the UK government's legal service in DEFRA, and with NGOs, Friends of the Irish Environment and the National Trust for Ireland, where he was a Natural Environment Officer and in-house solicitor. Dr. Jackson's been involved in public interest, environmental and planning law for many years, including before the Irish, English and EU courts. Dr. Jackson, thank you very much. The floor is yours, and we look forward to your case study.
Thanks, Tavis. At the time of writing my chapter, several years had passed since Ireland's Climate Act was adopted in 2015, and we therefore had some experience of the Act and practice to inform the discussion. The chapter looks in detail at the history of Ireland's Climate Act, as well as predecessor legislative efforts that failed for various reasons. Having considered this historical context, the chapter considers three potential characterizations of the Act. The first views the Act as symbolic legislation, not really intended to be legally effective. The second examines the Act as a Trojan horse, in other words, subject to litigation despite the government's apparent intent to avoid this. And the third examines the Act as a stepping stone en route to more meaningful regulatory intervention. In terms of the history, from 2005 until 2011, political parties in Ireland engaged in a sort of game of legislative ping pong, if you will, with several iterations of relatively good framework climate legislation proposed but ultimately never adopted. Ireland's Green Party was in coalition power at this time, from 2007 until 2011, with the Green Party minister holding the relevant portfolio. In the wake of the passage of the UK's Act in 2008, the two leading legislative efforts in Ireland were a cross-party initiative in 2010, led by a parliamentary committee, with this bill clearly inspired by the UK Act, incorporating carbon budgeting and so on, and a government bill led by the Green Party that, looking back, was not as strong as the cross-party initiative. The government bill contained relatively ambitious targets, but they were expressly non-justiciable. And in any event, the Green Party bill emerged very late in the day, just after Ireland's EU IMF bailout in late 2010, with the government just weeks away from collapsing. Now, these relatively ambitious legislative efforts died with the government's collapse, and under the subsequent government from 2011 until 2015, we saw ambition dissipate amidst calls for realistic climate legislation. What emerged ultimately in 2015 was a very disappointing piece of legislation that doesn't measure up well at all against leading climate laws in other countries. The 2015 Act has the trappings of a framework climate law, but with most of the most effective elements removed. For example, not only does the Climate Act 2015 not incorporate the concept of carbon budgeting, it doesn't even contain targets. Even the 2050 objective is framed in woolly terms to pursue and achieve the transition to a low carbon, climate resilient and environmentally sustainable economy by the end of the year 2050, whatever that may mean. The chapter concludes that Ireland's Climate Act 2015 is an example of symbolic legislation, that is, legislation not intended and expected to be legally and substantively effective, but enacted with certain political strategic intentions. The chapter notes that despite the government's best intentions to make the Climate Act litigation proof or immune from litigation, the Irish government nevertheless ended up before the Supreme Court, as Richard mentioned, in respect of its first national mitigation plan, which was ultimately found unlawful, with the Supreme Court managing to give the Act some sort of teeth in the process. This was a case I acted in, incidentally. And finally, the chapter notes that the Act is perhaps best viewed as a mere stepping stone en route to more meaningful regulatory intervention. Indeed, the process of producing a more meaningful Climate Act is likely to reach its conclusion in Ireland next month, when the current government, under another Green Party minister, passes an amending bill that, despite its own weaknesses, will substantially improve the Climate Act. And here we've really seen clearly the practical value of the book we're launching today, with its case studies and its analyses helping to inform commentary on Ireland's amendment bill. The chapter ultimately concludes that in pursuing a weak, symbolic climate law in 2015, Ireland's government embraced the politics of predatory delay. And for that, I argue, history will not judge it kindly. Thank you.
Thank you very much, Andrew, for that critical reflection on the Irish Act. Now, colleagues, we have 2 more speakers on our podium, but just a reminder to our audience, do please post your questions in the live event Q&A. I've written down about at least 13 questions for our panel here from the fascinating discussions so far, but do post your questions. We can ask them at the end of the session if that we have some time for discussion. So next, it's my absolute pleasure to introduce Asa Robson. He's from the Swedish Environmental Research Institute and Senior Researcher in Environmental Law and Policy. Asa holds a LLD in Environmental Law from Stockholm University, where she's board member of the Centre for Environmental Law and Policy. Asa has been an acting politician and was Sweden's Minister for Climate and Environment from 2014 to 2016 at the critical time of the Paris Agreement and the formation of the new Swedish climate policy framework. You cannot get any more at the centre of the action than that. So Asa, it's my pleasure to hand the podium over to you.
Thank you very much, and I think you can hear me. Can you?
Yeah.
Yeah, that works. Thanks, Richard. I'm delighted to be joining you, and many thanks to Thomas that invited me to participate in this volume and being able, together with a Swedish colleague of mine, we wrote the chapter on the Swedish policy framework with the Climate Act, which is actually a fairly simple one, only a few sections, and in many ways would, as you would say as a scholar, it would be more like a signal act, or in the best a stepping stone. But having a bit of the background, I think you might be able to see it as a stepstone for a future more credible act of climate change, also for the Swedish sake. And it's a bit astonishing in the way that Sweden, being the country wanting to take the lead, having quite a few progressive actions taking on climate change well beyond and before the Paris Agreement. It was forefront in the Kyoto Protocol, and having actually the already seeing what a target setting politics could actually do with the emissions. Getting the Kyoto Protocol and setting the emission targets, also even the most progressive parties in the parliament, the Green Party. I was a spokesperson for several years. Even that party would not assess that the targets on emission reduction could go as fast and as simple as it could during the Kyoto Protocol era. So having the experience of being quite an effective way of setting policies, one might think that even taking a legal action and taking a legal framework would be easy. However, it wasn't, and it was quite hard time to get the idea planted in the Swedish legal sphere to have also a climate act. It was actually inspired very well by the UK Act, but also on the set that we had in Sweden, or have already since the 90s, for the financial sector in the system, an act that obliged the government to take certain procedures to Parliament, not to be able to kind of undercut the economic strength of the country. And that act was also very helpful to mirroring and forcing the major political parties to actually agree on a climate act, although it's a very simple one to this stage. This process was done also very much in the light of the Paris meeting, because the committee preparing the Climate Act and the climate policy framework, they were actually joining and following the discussions in Paris very much, and I had very many examples of how those persons personally, I mean, there was representatives of parliaments from all parties, and they were all saying to me later on, it was, well, we know we took very much, we got very much knowledge from the process of Paris meeting and the international negotiations and all the actors stakeholder participation in Paris to actually understand why we need this kind of framework also in Sweden. So international knowledge gathering and spreading the word is very, very important. I also want to say that I think there was a shift, which is in the political sphere, that's important to see, that a country like Sweden having progressive policies for decreasing carbon emission is one thing. But when it comes to after the period of Paris, when the whole world actually agreeing on phasing out, we need to, I mean, getting free from fossil emissions, that is a total different thing. Then you need to have a plan for phasing out in a down to zero, and that I think has helped also to the conclusion among the policymakers that the legal frameworks are very, very important to take a side on. You cannot only do it with some economic reforms and political agenda. You do need the full regulatory framework to deal with that. And I think that was a conclusion that Sweden now is working on. And what I can see from the Climate Act is that it has forced the government to also take action for even further enable new legal arrangement for permitting, for example, and that is definitely a conclusion of it. So, with those words, I want to thank for this.
Thank you, Asa. Thank you very much from the perspective from Sweden. Now it's our last speaker today is Professor Otto Spijkers, who is a professor of public international law, joining us from the China Institute of Boundary and Ocean Studies at Wuhan University. He is a member of the Committee of the Role of International Law in Sustainable Natural Resource Management for the Development of the International Law Association. Otto, I imagine it's the evening for you as well. Thanks for joining us at this time, and the floor is yours. Thank you.
Thanks very much, Tavis. Yes, it is close to 7 in the evening here in Wuhan. So even though I'm speaking to you from Wuhan, I actually focused my chapter on my home country, the Netherlands. So I wrote my paper on the Climate Act, the Klimaatwet, and the Netherlands Climate Agreement, Klimaatakkoord. And I did so together with Sophie Oosterhuis, so I have to acknowledge her contribution. We wrote it together. So our chapter provides an analysis of the substantive and procedural elements of these two documents, and a separate section is also devoted to the relationship between these two documents and the Urgenda litigation that everybody is always talking about. So on June 28, 2019, the Dutch cabinet presented its climate agreement. So the climate agreement encompasses a package of measures between companies, social organizations, and government bodies for the joint reduction of greenhouse gas emissions from the Netherlands. This climate agreement is the result of consultations among 150 parties that gathered at environment-themed roundtable meetings. And then in September of that year, in 2019, the Climate Act entered into force. So this act is a piece of legislation that provides a framework for the development of policy in the Netherlands geared towards a permanent and gradual reduction of greenhouse gas emissions from the Netherlands, with the purpose, of course, of curbing global warming and climate change. A third development, which runs parallel with these two, is a tort case initiated against the state of the Netherlands by a foundation called Urgenda. This tort claim is not based on either the Climate Act or the Climate Agreement that I introduced to you earlier, because the initiation of this tort case was done before these two acts entered into force, already in 2013. So basically, Urgenda then it was successful, and the Dutch state was ordered to reduce greenhouse gas emissions by at least 25% as of late 2020 relative to 1990 levels. So these three developments that we discuss in our paper, the Climate Act, Climate Agreement, and the Urgenda litigation, are closely related to each other. The Climate Act, it binds the government in its relationship with the Dutch Parliament and the Senate. So in that sense, it's an old-fashioned piece of legislation. And the Climate Agreement is a series of non-legally binding, I want to emphasize this, commitments made by governmental bodies, but also by companies and civil society organizations in the Netherlands. But they both have the same goal, to reduce greenhouse gas emissions from the Netherlands, and they operate in parallel and have been drafted simultaneously but through separate processes. So Climate Act binding, Climate Agreement not binding. And some companies based in the Netherlands have also signed up to this Climate Agreement. And interestingly, Shell, the global oil company Shell, is one of those companies that has committed itself to the agreement, knowing very well that it was not legally binding. But then we might need to nuance the rigidity of this difference a little bit, because on the 26th of May of 2021, so very recently, the Hague District Court delivered its judgment in the case initiated by Friends of the Earth Netherlands, Milieudefensie, against Shell. And the court agreed with the claimants, to everybody's surprise, that Royal Dutch Shell was doing too little to reduce greenhouse gas emissions and to prevent serious climate change damage. So in this judgment, reference was made to both the Netherlands Climate Act and to the Netherlands Climate Agreement. The latter was signed by Shell on 12 September 2019. And thus, said the court, this agreement, despite its legally non-binding character, could be used by the court to give concrete meaning to the duty of care of Shell. So next time a company in the Netherlands commits itself to a non-legally binding agreement, it might want to reconsider signing such an agreement, because it might actually be used against it by a court of law, as was done against Shell in this case. I thank you for your kind attention.
Thank you very much, Otto, for that very recent and very interesting case as well, which certainly has sent shockwaves, both I think probably in the legal dimension and in the energy industry as well. There's been a lot of debate about that. So we have some time.
Avoid disappointment among the readers, I did not mention the Shell case in the book because it came after the publication of the book.
That will be in the next book, I'm sure, as well, and we're looking forward to both the current and the future versions as well. So thank you very much, Otto, and thanks for joining us from China. We have a little bit of time, not a huge amount of time for questions, but we might get through a couple at least, and I'm sure the panelists won't mind if we go just maybe a couple of minutes over if we have some questions, but not too much longer over for our audience. So our first question we have here from Russell McKenna, our chair in energy transition here at the university. And Russell asks, there seems to be a tension between long-term climate targets and short-term perspectives of political decision-making. How do the panel propose to reconcile these two dimensions, and who should carry the can, i.e. who should take responsibility in the case of non-fulfillment? Maybe a couple of thoughts on that from anybody, if anyone wishes to jump in.
Well, I mean, very, very briefly, I do think the combination in the UK Act of the longer term carbon, the 2050, which doesn't actually seem that long term now, and the 5-year budgets, is designed to try and deal with that, if you like. I mean, the tension in the Act, which we just don't know yet what this actually means, is that it does say, yes, that long-term target appears to be a legal duty, as are the budgets. They have to, produce policies that will meet the budgets. But then there is a provision saying, if the Secretary of State doesn't meet the budget or the long-term target, he has to report to Parliament and explain why and say what he's going to do. And I think it will be very interesting if it ever gets to the courts. Will the court say, well, actually, this act is designed as a political accountability. You know, we can't intervene. I think the compromise is that the courts would say, well, we can make a declaration that the Secretary of State is acting in breach of the law because he hasn't met either the intermediate budgets or the long-term target, but we're not going to get involved in dealing with the actual remedies to deal with that because he has to report to Parliament and explain why, and that's this balance. But it's a provision that always intrigues me, precisely what the two is meant to do. I think it's very interesting, but I think running throughout that bit of act, as I've tried to explain, is both political accountability and a kind of legal accountability, and I think that's very interesting in this particular field of climate change. I think it's really important.
Elena, I saw you had your hand up there as well. You had a comment to make on that question.
Yes, just to complement Richard's contribution, I think bridging that tension between long-term targets and short-term political perspectives is one of the main objectives and benefits of Framework Climate Acts that we're discussing here today. And I think in addition to ways that Richard just explained and the role of courts in that process, an important provision, apart from reporting, the government reporting to Parliament, important provision that emerged in the UK Act and then was picked up by Mexico and many other countries, is the role of independent expert advisory bodies in that process, which provide an independent assessment of, in the case of the UK, both of the policies which are being proposed to meet the targets, but also of the progress being made in implementation. In the case of Mexico, it's just more the latter than the former, but basically such independent expert advisory bodies play a key role in keeping the government accountable for both the long-term and short-term targets that are put in the legislation.
Thank you, Elena. So I have a question from the chair, and it's a slightly provocative one because it'd be very unlike me to do that. And I'm going to target this one to both to Prue and to Thomas, actually. And my question is about the relationship between, say, national climate acts and, say, devolved or state level climate acts. And so two examples, Thomas, you are thinking here about the UK situation with the relationship with the UK Act and, say, the Scottish Climate Act and what's happening currently in Northern Ireland. Prue, I'd like to contrast what your example with what I am happy to describe as the lackluster approach of Australia on national climate legislation, but actually really robust and strong responses from, say, the states in Australia around climate legislation, contrasted with the very progressive approach that's been taken in New Zealand. So this issue of how the National Climate Act interacts with sort of more devolved legislation. Thomas, do you want to lead off on that one?
Yes, I can indeed. Thanks for the question, Tavis. This is quite a difficult problem. I won't get into, there's some sort of governance intricacies between, say, a devolved system and a federalist system and that sort of thing. Won't get into, but dealing with the sort of the point of broad principle and as concretized in the UK experience, that we have, in essence, a national level of governance that has certain powers, and other powers will be devolved to a sub-state level of governance or subnational level of governance. And that constitutional circumstance will pose complex challenges in the area of climate. It does raise interesting problems and questions. First, let's recognise we have these constitutional circumstances in the UK, elsewhere as well. Climate is a particular sort of slippery fish, really, because we're tending to try and implement economy-wide decarbonisation. That's a particular challenge for a legal schematic as well. So we're dealing with pervasive sort of economy-wide matter typically, and that's before we even come to issues like adaptation, which are conjoined in a sense with mitigation. The way the UK has had to grapple with that issue is to, or the way it has chosen, is to put in place a national legislative framework that Richard's discussed very well for us, the Climate Change Act 2008. When that national act was introduced, it goes into a constitutional environment where devolution operates, and you find that some of the main levers of control that the act is trying to mobilise are not really at the national level. Northern Ireland's a great example where I'm speaking to you from and where I am from, because energy competence is substantially devolved to Northern Ireland. So you have a national act that is going to rely in significant part on energy decarbonisation. It's trying to do certain things. Yet when you look at where the levers of control are in the case of Northern Ireland in the area of energy competence, you see right away that powers are devolved, and it poses tricky complexities. There are certain ways around that and certain things the Act endeavours to do. It was also interacting with complex EU regime drivers when it first came in. But long story short, what's occurred is Northern Ireland at the present time has tried to take some leadership of the issue subnationally by constructing its own climate bill. That is in our devolved parliament at the present time. Strangely, a second bill has been introduced just yesterday. There are two climate bills in Northern Ireland, so it's rather feast or famine. Scotland is further down the road, much more well developed. It has had a sub-state Climate Change Scotland Act 2009 in place since 2009 that does a range of novel things in the context of devolution. So I'll maybe stop there. Rather than picking through the intricacies that undergird your question, I'm more, in a sense, emphasising the question's a very good one. We do have these multi-level constitutional problems that need to be attended to when we engage with these acts, and they're absolutely inescapable. The UK is a good testing ground for how one might usefully do that, and we can see problems, errors, successes in the UK setting that may usefully inform other jurisdictions as they approach those sorts of problems. Thanks for the question.
Prue, any further comments from the New Zealand context, another Westminster-based system?
Yeah, I mean, I can't offer you any comment about the situation in Australia. I can offer you some comment about what's going on in New Zealand, which is quite interesting because we're an incredibly centralised system. But nevertheless, there is a lot of tension in New Zealand between local government and central government, and this tension has been largely ignored by the New Zealand climate change legislation, much to the annoyance of local government, and they have made local government authorities have made endless submissions both on drafts of the legislation, and also our Climate Change Commission just put out their first advice on the first 3 budgets. And again, local government was quite critical of the lack of attention to the responsibilities that local government have, and the lack of guidance given to local government. And the lack of attention to how important legislation that gives local government all its responsibilities, the lack of attention to how these pieces of legislation should operate together. So this is a whole area where central government has basically glossed over it, and they need to come back to it. And one key area is actually climate change adaptation, because local government has a lot of legislative responsibilities for climate change adaptation, but they also have a lot of legal liabilities, and they're constantly asking central government for what is your guidance to help us both with our legal responsibilities, but also to help us with our legal liabilities. So the upshot is that there's still a lot of work to be done in New Zealand to ensure that central government stops treating local government like an inferior branch of government, but rather to see local government as we do in the international legal domain, that local government and subnational government is incredibly important to delivering on both mitigation and adaptation. For some reason, this just hasn't gotten through to central government in New Zealand very well.
I think, Prue, that you find that might be a fairly common issue across the board in many instances as well. We face certainly challenges in the UK around that, and Scotland around that as well. We're over time now, so I just want to ask one final question. Some of our other speakers who haven't answered may want to jump in. Another slightly provocative one here. So based on the case studies today, and this may be something that's discussed a bit more in depth in the book, are climate change acts the domain of Western liberal advanced economies in the global north? What is the role of the global south and developing countries in developing climate change acts, legislation of equivalence?
Can I just comment? Well, I come at slightly different perspective, but I do find it quite useful. and this isn't really my characterization, but it's an old colleague, Tom Burke, who works in sort of environmental field, and he's always very interested in legislation, and he's sort of characterized what he calls old environmental legislation, which is things to do with things like water pollution, waste pollution, noise, land contamination, and all of that, and what he calls the new environmental legislation. And the thing with the old legislation, but it's still with us, is that we sort of know what the solutions are, the technical solutions. We sort of know what laws actually work and what needs to be done. And very importantly for governments and a democracy is that there's normally a win-win situation. You know, you get rid of illegal waste disposal, the legitimate industry likes it, a few people get out of. So the trouble with the new environmental agenda, and I would include climate change in that, is that often, I mean, the science is developing all the time, we're not quite sure. We don't actually quite know what laws actually work. You know, we've got this framework, but do we always then use regulation to implement it or other things? And I think more importantly, and I think this is why I mentioned about this, you know, the next budget, is that, you know, it's not in the short term necessarily win-win for politicians. You know, the public are going to begin to feel like we're talking about the whole of the UK may have to change its heating systems, domestic heating systems. That's going to be a big challenge, particularly people. And we're not. It's not that kind of old. Now, the problem with emerging economies is that they're actually often dealing with both sets of laws and policies at the same time. You know, they're dealing with water pollution, they're dealing with it, but they've got this longer term thing, and that's a real challenge. I haven't got a solution to it, but I think it's quite useful. I quite often think in terms of those sorts of laws and what I call the new and the older type, and the challenge for the emerging economies.
Asa.
Thank you, and thank you, Richard, for such good thoughts on this. I totally agree about the old and new ways of legislation. It works well. I wanted to add just some thoughts backing from the Paris meeting, and profoundly that the climate change issue there was so easily packed with an issue for all countries, and especially for emerging countries and developing countries, an immediate issue. So I would say, reckoning that the Swedish climate policy framework and the Climate Act, totally ignoring the whole adaptation issue, that is maybe the starting point for a lot of other countries for climate policies, and therefore I expecting climate legal development also to be very relevant in emerging economies, as was covering here from Mexico, but even more in developing countries, because of the urgency, and because of the urgency also to do planning, not just in short term, but in long term. And I would be quite expectful that those kind of legislations in those countries may also be able to, because what you need is a system that could deal with the tensions coming in society because of climate change, and that kind of legislation could deal with that, or at least trying to sort out how those kind of conflicts could be solved in a robust and more democratic manner. Maybe also in dialogue, of course, with other countries, because that is the unfair situation for developing countries, that the issue of climate change is always coming back to you as something that is totally unfair. Also, of course, for the young generation. So here we can definitely see that the legal scholarships and legal thinking would need to develop.
Thanks so much, Asa. We're at 10 minutes now over time, so just before I hand back over to Thomas, I just want to thank our distinguished guests and panelists for the fascinating presentations today. Richard, Elena, Prue, Andrew, Asa and Otto, it's great to hear from you. I can't wait to read this book, everybody. This should be on your reading list for your students and departments and bookstores. It's a fascinating book, it's a timely book, and it's an incredibly relevant book in an area which is so important as we address our climate change commitments and the just transitions going forward. So thank you very much for joining us from several different time zones today. It's been a pleasure to host you, and I look forward to seeing you again in the near future. Thomas, thank you very much, and back over to you to close the session.
thank you very much. I just reiterate my thanks to the CET, to Tavis, to the technical team that helped us draw this together, to all my friends and colleagues who have contributed to the book, those of course who are here and some who couldn't be with us but send the best regards, and also Lord Karnwith as well. I hope people engage with the book and enjoy it, and remember my encouragement to consider it as a first comprehensive research statement, so not the last word, a beginning, not an end. This is a very rich area of law that unfolds all the time, and we want to be part of that conversation and really think carefully and hard about how law can most adequately contribute to redressing one of the most difficult challenges of our times in this area, the area of national framework climate legislation, and the many other areas that intersect with it, litigation and so on, and indeed beyond that. So thank you all very much, and I look forward to continuing the conversation, as it were, as we all go forward. Thank you.
Thank you.